How do I evaluate my personal injury case? Hi, I'm attorney Pedro Juarez. I'm an attorney here in Boston. I focus on personal injury law, specifically motor vehicle accidents. Before I became an attorney, I was an adjuster for over 10 years, so I feel very competent in this area of the law. Okay, just right out the gate, there is no secret formula to calculate your personal injury case. Um, there are no schedules like in workers' compensation claims where there might be a schedule as to how much your injury is worth. In third-party personal injury cases, that's not the case. So there is no formula. So what I'm about to say, just take that for what it's worth. Everybody has a different method, and depending on the severity of the case, depending on the insurance company or the insurance coverage available, depending on your lawyer, depending on yourself, depending on where you are, if the case is going to trial, that's all going to factor in as to what the case is ultimately worth. Let me just say that insurance companies, for them, this is just a financial evaluation. They often neglect the social impact that this causes to your life. And for them, this is a financial transaction, right? Their interests are with the shareholders to maximize profits, which means that their goal is to settle the case as cheaply as possible. And that should come to no surprise to anybody viewing this video. Let me read. This is a jury instruction from the Massachusetts court. So let me read this to you. There is no special formula under the law that to assess the plaintiff's damage. The law does not require the plaintiff to prove their damages with mathematical precision. You must use your wisdom and judgment and your sense of basic justice to translate into dollars the amount which will fairly and reasonably compensate the plaintiff for the injuries. So that's a jury charge from what the judge would instruct the jury on how they should determine the damages or the value of the case. So, again, there's no mathematical formula. It's really just based on a person's sense of justice and their wisdom and their sound judgment to try to compensate the plaintiff for their injuries that they sustained. There are two broad categories of damages. You have economic damages and you have non-economic damages. Economic damages is what they call special damages, are things that are tangible expenses. Any out-of-pocket expenses, lost wages, medical bills, etc. And I'll go into this more detail in a few seconds. Then you have your non-economic damages. This is what they call general damages. And this is for the intangible stuff, basically your pain and suffering claim. Okay, focusing on economic damages, like I mentioned, it's for past medical expenses, so medical expenses that you incurred since the accident until the date you're trying to settle this or it's going to trial. But it also looks forward for future medical expenses. If you have severe enough injury and the injury is not going to heal, then you're going to have future medical costs. It might be a knee injury or a leg injury. You might need a knee replacement in the future. So you have to calculate those damages, and that has to be included in your settlement. Uh, Earning capacity. So similarly, you have your past loss of earning capacity and you have your future loss of earning capacity. Lost wages. If you lost time because of the injury or the accident, and it's not just the monetary value, but also benefits. So if you used the sick time, PTO time, that all should be compensated by the insurance company or by the wrongdoer. Then you have replacement services. This might mean that, hey, I used to mow my own lawn or I used to shovel my own snow, but now I can't and there's no one else at home that help me this and I have to hire somebody. These are all services that you're going to need to, or expenses that you're going to have to pay out of pocket now and in the future. So you should be compensated for that as well. It might also mean for any medical devices that you may need in order to, again, try to get you to the position you were before the accident. Next, you have your non economic damages. So this means your pain and suffering, the intangibles. This is your mental pain and suffering and your physical pain and suffering. It could be also your emotional pain and suffering, right? If you want to draw a distinction there for your past pain and suffering and also your future pain and suffering if the injury is not going to resolve and you're going to have to live with that injury for the rest of your life. Permanency, which I just mentioned. Also, any loss of enjoyment, if it now is going to impact the quality of your life, obviously, and potentially loss of consortium. This is with your spouse or with your partner. Okay, so how do we calculate all this in order to arrive at a number? There are generally, again, this is not how everybody does it, but generally there are three models that insurance companies, attorneys, or juries use. So a jury, typically how I've seen it is they use a multiplier of damages, and some attorneys use this as well. Insurance companies use a per diem analysis or sometimes a per week analysis. And then other attorneys try to use a coverage availability analysis. So for the multiplier model, basically what you do is you calculate or you add all of your special damages, your economic damages. You tally that up. So, for example, you have $30,000 in medical expenses and lost wages. Then you add a multiplier. Typically, you multiply that by 2 or 3 times that amount. Um, if it's pre-suit, if it's not in litigation, typically it's 1.5 to 2 times that amount. If it's already in suit and it's going to trial, it might be as high as 3 or 5 times that amount. Again, it really depends on the jury and the case itself. But you can see how this model is not always the best model to use because if you don't have a lot of expenses, a lot of damages, economic damages, even if you apply this multiplier, it might not give you a lot of money. Again, going back to the example, you have $30,000 in damages. If you multiply that by 3, you come to $90,000, right? But what if you have surgery? What about if you have this permanent damage that you're going to have to live with the rest of your life? $90,000 may not be enough to cover all that. So, but that's one traditional model. The other one is a per diem analysis. Insurance companies like to use this analysis, but again, because they want to be more formulaic about it, they insurance companies most insurance companies use software to try to calculate what your claim is worth. And I can actually tell you that some of the values that we were using as adjusters 10, 15 years ago is still the same value as an attorney that I see today, which should be shocking, right? The price of eggs, gas, rent, medical costs, everything has increased, yet the formulas that they're using is still the same values that they were using when I was an adjuster. But how does that work? Essentially, they try to give a number per day, or they try to give you a dollar amount per week. And then they look at how long you were totally disabled, meaning that you couldn't go to work or you couldn't do your normal activities. They'll give you, number of days or weeks based on your total disability. Then they'll look at your partial disability, meaning that you could do your normal duties, you go to work and whatever, but you were still injured. And then diminished partial disability, they typically use that when you probably should have your injury probably should have resolved, but you still had some lingering effects, and it was just beyond the normal scope of what the the treatment needed for that type of injury. In this number, again, I don't hold me to this number, but typically it's somewhere between $300 to $400 a week is what the insurance companies try to use. But in the per diem analysis, you can see where you might run into some problems if you also have some long-term injuries or injuries that are permanent. This model may not capture the totality of your pain and suffering claim. And lastly, you have this coverage availability analysis, where you look at what's the total available coverage for insurance. Okay, you look to see what the policy limits are for the defendant, and if they don't have enough coverage, you look at your own policy for the underinsurance. And I'll spend some more time talking about uninsurance, and underinsurance in a different video. But you look at the defendant's bodily injury claim, you look at your own underinsurance, and you try to see what's available for coverage. If there is plenty of coverage available for your type of injury, actually, let me step back. Um, so you determine what the available coverage is, okay? Then you look at your economic damages. And if that exceeds the available coverage, well, that's a no-brainer, right? You're going to ask or demand for the policy limits because obviously there isn't enough coverage available to compensate you for the claim. It just gets a little more nuanced when there's plenty of coverage available. Let's just say there's $1 million available in coverage, and your economic damages are somewhat smaller, right? Not to say that the injury is not severe or serious, but your damages portion is a lot smaller. We'll just say it's $10,000, right? Then naturally, that's there's plenty of coverage to cover that claim if there's nothing serious or there's no permanency or residual impacts or effects that are gonna take place. Then you have to figure out what you're comfortable with in terms of settlement, right? But again, this is just another model that attorneys often use. And the question in this type of analysis is, when there's sufficient coverage, you simply just want to ask what a reasonable person would accept for this type of injury. What is the fair amount? And this might be done through asking a focus group, other lay people who are not in the insurance, to see how a jury would react. You may ask fellow colleagues or other attorneys based on their experience. You may look at yourself and say, based on my experience, what do I think this is worth? But you can see where this type of analysis is a little bit more subjective, right? Okay, I made this diagram just to show you that the value of your claim is going to depend on the severity of the injury and the medical treatment and how long you treat, right? And I think that makes sense. The more severe the injury, the longer you need to receive medical care, the more valuable your case is going to be, versus something that it was a light impact, the injury wasn't very severe, and the injury will resolve on its own, or the injury does resolve through medical care, through medical intervention, and you're back in a position you were prior to the accident. That claim, the value of that claim, is obviously different than an accident or an injury where You can't go back to the same place you were prior to the accident. When picking an attorney, you want to make sure that you have an attorney that is going to educate you about the process, that is going to protect your interest, and it's going to advocate for you. So, educate is really to explain to you what the process is, give you candid feedback, give you an analysis, an objective analysis, so you as the client make the best informed decision, right? Because ultimately, it is the client who decides what is a fair settlement and when to accept that settlement. It's the attorney to educate the client on whether it is a good settlement and what are the strengths and weaknesses of the client's claim. To protect, obviously, the attorney has a duty of loyalty. They have a duty to safeguard their property. There's a confidentiality duty, and to avoid any conflicts of interest. An advocate is when the attorney is acting on your behalf against the defendant's attorney or defendant's insurance company. They're going to advocate on your behalf, right? And they're going to advocate zealously if they can, but still within the bounds of the law. They're not going to help you um, lie or commit fraud or misrepresent the facts of the case. They still need to operate within the bounds of the law, despite what you see on TV. There is an ethical duty that attorneys have to their clients, but also to the court. So, with that, the quality of the firm does matter. And I know this personally from working as an insurance adjuster. There is a premium that insurance companies will pay if they know that you are represented by an attorney. If they know that you're not represented by an attorney, the offer that they're going to give you is going to be well below what they normally offer. But even if you are represented by an attorney, uh, there's a difference between attorneys. There are those attorneys that just want to settle the case as quickly and as cheaply as possible because they don't have the experience. Maybe they don't have the resources. Maybe they don't want to take it to trial. They don't have the time. And now versus an experienced attorney, a bigger law firm, and attorneys who take cases to trial and take verdicts. Insurance adjusters do know, especially the managers and the directors of insurance companies, they have they know who the real players are in the state or in that jurisdiction for their field. So they know um, who's actually going to take them to court and who's just going to accept a quick and short settlement. So keep that in mind when choosing your law firm and attorney. Okay, in closing, factors to consider in all these models, it's the liability, it's comparative fault, it is the damages, it's the medical treatment. That all matters. The severity of the injury, that all matters in um, trying to calculate the value of your case. So there's no magic formula to plug in. Even insurance companies try to do that, but it doesn't always work out that way, right? It is based on it's subjective in the end, because even if it goes to a jury, the jury has to decide, and they're lay people. They don't have any experience handling claims, and they need to use their sound judgment. So it's going to be very important that you have an attorney that has experience and can kind of guide you and educate you throughout this process in order to get a fair settlement and something that you as the client will be comfortable accepting and living with, right? None of this is legal advice, so please don't take that as such. I am just providing you educational information. If you have any questions, please consult an attorney in your state or jurisdiction. Find somebody that is competent and that you trust. If you want to contact me, feel free to send me message or send me an email or book a consultation, and more than happy to talk to you about your case. Um, Happy to hear everyone else's experience. If there's any crazy stories out there or your crazy own experiences handling or going through the claim process, I'd love to hear it and communicate with everybody. Thanks for watching and have a good night.